Let's go to 170 People versus Afilal. I haven't heard enough about it, and it involves your case. And after you introduce yourself and tell me how much rebuttal time you want, tell me on this particular issue, what happened in your case?
Thank you, Your Honor. On behalf of Appellant Mr. Afilal, the Legal Aid Society by Seth Steed, I was going to address...
How much rebuttal time?
2 minutes, please.
2 minutes. Address Terrell first.
Address Terrell first. So in this case...
What's different about your case than all of these that we...
All the other cases were silent records. In this case, it wasn't a silent record. And on the spectrum of pleas, this one was probably better than most, but still woefully deficient under Tyrell.
What did counsel say about these kinds of rights in your case?
What did counsel say?
No, what was gotten on the record about these rights? On
the record, the court asked my client, was he pleading guilty? Because he was in fact guilty. Did he understand there may be immigration consequences? And there was a factual allocution, and the word trial was mentioned in passing. And did you discuss the consequences of this plea with your attorney? That's what happened here.
Good enough?
There was no...
Good enough?
Absolutely not.
Why not?
There was no mention...
Why isn't this almost a gradation on everything we were talking about before? Here they don't use the word Constitution, but they use the word the consequences of taking the plea. Why isn't that pretty close to some kind of a statement on the record that this guy gets it, he's given up his constitutional right? Well,
because there was a complete failure to talk about the other two Boykin rights that apply
So
here.
in your mind, you got to mention all three of them?
The court is not required to mention all three. What happens is that from all the on-the-record evidence in the case... You got to convey that you've given up all three? Correct. And in fact, I think Judge Rivera earlier said, well, what if the court asked counsel, did you discuss the Boykin rights with your client, and did he waive them and understand them?
Right.
If that had happened here, that might have been okay.
Here, but this on the consequences not enough?
Say it again? You know?
This on the consequences, understanding the consequences.
Just saying understanding the consequences. The consequences may be that he is sentenced to time served and has to pay a fine. And then there was a break in the proceeding. Counsel asked the client, if client needed time to pay the fine. So I think what's interesting is there's some recent cases that deal just with this from the Third Department, the Mons case and the Vences case that I cite in my reply. In those cases, there was a passing reference to the trial right, but not the other two Boykin rights. And there was a discussion, did you consult with counsel about this? And in fact, in the Mons case, they adjourned the case for 1 day for the client to discuss the ramifications of the guilty plea with counsel for another day. But when they got back on the record the subsequent day, there was no further discussion on the record about what that conversation was.
Okay, counsel. So you have a variation on a theme in these kind of cases. What was the issue you wanted to start talking to us about?
The facial insufficiency issue.
Go ahead. Let's hear about that.
So in this case, my client was charged with misdemeanor marijuana possession in the 5th degree for possessing marijuana, quote, opposite of 676 Riverside Drive. And there are no further factual allegations about
what could that mean about
that? And that's my question.
Well, are there buildings on both sides of the street?
There are. 676 Riverside Drive, I looked it up, although this is the horse record. It's on Riverside Drive at 145th Street. Going westerly is Riverside Park. Going northerly, because this sits on an intersection, is a private building. So we don't have any indication, and there's no further facts. It's just conclusory pled.
So your position is the opposite side would be the westerly, the northerly side where the building is, as opposed to the park side.
My position is that I don't know, and it's the prosecution's responsibility.
What should they have put in the?
They could have said a bunch of things. They could have
said in a public place. Isn't that enough?
That's a conclusion, Your Honor.
Yeah, but didn't you waive filing of an information?
So this is scrutinized under the complaint standard, where there has to be reasonable cause.
Why? How could it not be a public place, that address? What's confusing about that? Does it have to be with such great specifics? What can we glean from their saying, whatever it is, 676 Riverside? Why is that not a public place?
You can't glean much, and there's a footnote in my.
What would be the different alternative that it could be?
It could be a private. It could be a private place. I point to the McNamara case and the Matthews case from the First Department last year. Those were public lewdness cases, but nonetheless, the allegations were that the defendant was engaging in lewd acts inside of a car, and this court held in McNamara in the First.
So that it's not that The statements in the accusatory instrument don't say whether it's inside or outside? Is that
Correct.
the point?
Correct.
Well,
And
you don't
there's-
know, well, wait, you don't know what's there. How can you say it should be inside or outside?
Well, that's what I'm saying. We don't know anything about the nature of the
They said
location.
it's a public place.
They said it's a public
Right,
place.
and so is there anything contradicting that?
Well, it's an essential element of the crime.
That it
There's-
be in a public place?
Correct.
They said it was in a
And if-
public place. I'm
They have to
losing
tell
it.
us more about the nature of that place.
I've never
More
been
than-
there. So if I'm the judge and they say, Judge, you know, it's not a public place, what am I supposed to do? I mean, because you waived filing of information. You said, you know, we want to plead guilty, and they go through this whole thing, and he says, do you want to plead guilty because you're in fact guilty? And he said, yes. And now we're going to say what?
That this complaint, the complaint stage is very important. This what gives the prosecution and the government the ability to exercise jurisdiction over an individual.
Right.
And at a minimum, there has to be reasonable cause to believe that the crime occurred. For marijuana possession,
Aren't we looking here at this stage at a complaint as opposed to information for notice? Do you have sufficient notice of the incident and so the defendant can protect himself, and the double jeopardy consequences? You got to deal with that. Aren't they satisfied here? Why wouldn't they be satisfied in terms of notice?
I think when you look at Drayden, which was a knife case where the allegations.
Gravity knife cases, yeah.
And it was conclusory pled that it was a gravity knife. Here, it's conclusory pled that this was a public
What would you
place.
like that, if you were the prosecutor, what would you put in?
I don't like to imagine me being a prosecutor, but if I
Police
was,
officer.
it would be on the sidewalk inside of the park where there were other pedestrians walking by, something that would give the court an understanding about the nature of the location. And there's cases that deal with this. There are trial court cases and a recent appellate term case where the appellate term case found the allegation at 514 Target Street in Staten Island not good enough because saying out of address doesn't let us know it's a public place. The case directly on point, the Nemhar case that I cite to, said opposite of 177 Nagle Street. So
And
actually,
is it in fact true that he was not in a public place?
I don't know, Your Honor.
I pled guilty to it, that's why I'm asking.
He did plead.
He said, I possess marijuana in a public place.
And that was a conclusion. That was part of his factual allocution, correct. But what I'm talking about is before we can get to the guilty plea, the prosecution has to allege facts that make out a
There
non-conclusory.
were two police officers who saw this defendant with
Correct.
the marijuana in his hand.
Correct.
So you're saying they had to be inside of a building? They couldn't be on the street seeing this? That they possibly could have been inside of a building? Is that what you're saying?
I'm saying my client could have been inside of a public place, inside of a private place, sorry, and we don't know the nature of the location, and that changes the crime. It's no longer a crime, it's a violation. It's unlawful possession of marijuana. And Your Honor raises an interesting point. I think this case is kind of dubious. They're saying at 10 o'clock in the morning, they saw my client dangling marijuana out in the open. So
No, it said he had it in his right hand.
he had it in his hand. It wasn't burning in open. It wasn't burning, but it was open to public view. But
Well, you know, I was wondering about that because in the Jackson case, they could smell the marijuana. I don't know if I think you used it, and it's kind of a similar case to this. But I thought in the complaint the officer said that he could smell it also.
in this case,
Yeah,
I don't recall. I think the allegations were that he recovered marijuana.
on A4 of the record, I'll go back and look at it.
It says that the opponent observed the defendant holding marijuana in a public place and open in public view. The opponent states that the opponent then observed police officer so-and-so, shield number in the precinct, recover one Ziploc bag of marijuana which the defendant had possessed in a public place and open in public view from the defendant's right hand. It further states that the opponent believes the above substance, and they go into what it was.
The odor emanating from the substance and the observation of the packaging is characteristic of this type.
And that's after it was recovered. Those are the allegations about his expertise that allow him to
So
identify
we knew it
it.
was marijuana because he smelled it, not because it was burning.
Correct. So there's two.
No, I see. No, there's a rational distinction.
Well, it
So in
says,
part, you're arguing that the lack of an address must suggest what? You can infer that why
That
isn't
we
the
don't-
inference, if there's not an address, it's the park,
We don't
an
know.
open public place?
We don't know that, and I think the McNamara case and
I'm
the
saying, why isn't that a proper inference?
because it's a conclusion without any evidentiary facts that are required by Drayden, and that's what really the problem is here. And there were two police
Counsel,
officers.
finish your thought. Go
Sure.
ahead.
There were two police officers. The prosecutor could have easily asked them, give me more information about the location. Was it in the park? Was it on a sidewalk? Was it across the street in a westerly direction? And they could have told that.
Okay,
and it
Gus,
could have
you
been
have your rebuttal. Let's hear from your adversary.
May it please the Court, my name is Alan Gatlin, and I represent the people on this appeal.
Counsel, how difficult it is to make clear where this is, that it's in a public place?
Well, look, could there be more detail? Yes. But these are complaints, they're not depositions.
No, we get that, but couldn't you do it? Is it so much effort to make clear? Because you're saying it's a public place. What about his argument that if you look this way, there's...
Well, the natural inference from the language opposite 676 Riverside Drive in and of itself would suggest it isn't the building, because if you met some other building, you would give that address. And I would remind the Court...
What if it had been in front of 676 Riverside Drive? Would that give you an idea that it would be public?
Yes. In fact, I think one of the cases defendant relies on, trial court cases, Sherman, it might be, kind of distinguishes at from in front of. They say at's no good because you could think at means in a building.
But what about opposite?
Well, opposite is more like in front of. Again...
Why couldn't it be inside opposite?
Because the idea is that is not the way people normally speak. You're entitled to use reasonable
You're
inferences.
saying opposite is across the street?
Across the
I
street.
didn't say across the street.
Because he said the officer
I
wasn't
didn't say
thinking.
in the park. I mean, all of those have more detail. I understand your argument
Yeah.
is you don't need to give more detail.
And that's...
The question is why not?
We are not suggesting that this is the ideal complaint, but you also have to keep in
Well,
mind...
the question is whether or not it's sufficient.
Right. But again, it's sufficient. This is after waiver of information and after a plea, so the standard is notice to prepare a defense, double jeopardy projection. There's clearly notice to prepare a defense because he gave one.
Well, yeah, but I think your opponent's argument is that he waived the filing and everything after the motion to suppress or to dismiss the complaint for inadequacy was denied.
Yeah, that might be true, but notice, you would seem you look at the beginning. Do you have notice to prepare a defense from the complaint? The answer is yes, because he was
not
able...
knowing where the police claim, right, he is, where's the notice?
Well, because, first of all, they can go look, and defendant knows...
Who's the they can go look?
The defense attorney, defense
But
investigator.
that's his point, right? He says, if I look this way, there's a building. If I look that way, there's a park.
Well, that...
And either way is opposite.
Well, first of all, that's not, as a factual matter, that's not our understanding.
I understand it's
But
still
the
in the
other thing
record.
is, those might be lovely trial defenses. But again, we're looking at a misdemeanor complaint. Again, notice, yes, his defense apparently was, and he said in the omnibus motion, I was just sitting on a bench with my girlfriend. I didn't have any contraband in public view. So clearly, this was detailed enough for him to prepare a defense.
Under the lower
Under the lower
requirement.
standard, right.
Yeah.
Well, what about the merits counsel about this? What about the, turning to the merits, what about the court's statement that you're giving up your right to trial,
As a
but
trial? Well,
not all three Boykin rights?
Well, for you to rule in defendant's favor, you would actually have to overrule Harris in this case. In particular, there are 6 cases in Harris. 2 of them, Alisea and Ramsey, the judge, as in this case, elicited an express waiver of the right to trial, but didn't mention the other 2 Boykins. This court looked at all the circumstances and said the allocution was fine. Notably, this court listed other factors, such as defendant was represented by counsel, discussed pleas with the court, acknowledged the facts of the crime, admitted understanding the consequences of the plea, and said they were voluntarily pleading
What
guilty.
is admitting understanding the consequences of the plea? What does that mean?
Well, it could mean
In the
Harris didn't-
context of all we've been talking about today, about what you have to make sure that defendants' rights are preserved, what is aware of the consequences?
Well, it actually can mean several things. Like here,
Aware of the 3 Boykin rights?
it does. It's not limited to that because there are many consequences of the plea. Again,
But is it inclusive of that?
Harris didn't spell it out. It merely said the judge asked that.
It's good enough, right?
Well, it's good enough when you take everything in context. And Harris, as in this case, you actually have a judge ask, the exact quote is, do you understand by pleading guilty you are giving up your right to a trial? Yes, Your Honor. That's not a passing mention of the right to trial. That's a full allocution of that Boykin right.
Right.
And
And
again, that's...
and the consequences say
That-
a lot also, right?
Right, and you have to take everything in context. For 50 years, maybe more now, this Court has stressed the role of counsel. And something is important to keep in mind, it's not just that the defendant knows what the Boykin rights are, it's a knowing, voluntary, and intelligent waiver, meaning not only do you know what it is, you think it's a good idea. Well, the Court can't do that. That has to be counsel. It requires a discussion of the entire case.
But it's the Court's burden to get
Again-
the record straight, right?
That is, but then the question is, what is that record?
Yeah.
It cannot be a silent record. There has to be an
Right.
affirmative indication.
Right.
Here, where you have an affirmative showing of a waiver of right to trial, and you have defendants saying, I've discussed the plea and all its consequences, I'm satisfied with my counsel's performance, that's actually
So
more
here
than
the
you had in hand.
totality is clear to you.
Under the totality, it's clear. It's not necessarily that there always has to be a Boykin right, but here there was,
Okay.
and there was much more. Unless the Court has any questions, I'd
Anything
ask
else?
the
Okay, thanks, Counsel. Counselor, rebuttal.
Just briefly, we are seeking Burwell relief here. This was a relatively minor crime, and my client completed his sentence of time served. And mentioning trial alone doesn't satisfy the mandates of Tyrell. There's nothing on the record about the other constitutional
What
rights.
about the consequences language?
The consequences language still doesn't put on the record and show that the defendant knew about the constitutional rights he was waiving.
So
And
your
sa-
test, you got to mention all three?
In my test, all three have to be discussed, but the source of that discussion can be the court asking
Right.
the client, the court asking
the
defense
court-
counsel, the prosecution
The
can
court
be
is
involved.
setting the table, though. The court is.
It's the court's burden. Tyrell mandates that, but
But he says that didn't happen in Harris.
Yeah.
We have to overrule Harris?
you don't have to overrule Harris.
Why not?
There's been decisions since Harris. Hansen v. Phillips, which is a Second Circuit case, but looking at state case law is exactly on point with this case, where there's sort of one right given, and then the other third department cases.
If that's correct, then why do we even have to overrule this?
Because this was wrongly decided. The appellate term got it wrong here in saying that this plea was knowing, voluntarily, intelligently entered, where there's no indication that my client understood what trial meant.
Well,
even though
I
it
was struck
mentioned.
by the fact that the court said, you know, he denied all the motions in the case, and then he says, we'll adjourn for hearing in trial house March 6th. And defense lawyer says, Your Honor, we do have a disposition. The court said, all right, would you like to enter a plea? And he says, yes, my client authorized me. And they go on with all of this, and the judge says, you realize you have a right to a trial, et cetera. It seemed like it was the defendant that inspired the plea colloquy that morning or afternoon or whenever it was, and said, this is what we want, time served, we're out of here.
I think we have to infer a lot by what Your Honor is saying. What we need is on-the-record representations that this plea was knowingly, voluntarily, intelligently entered, and the client understood the constitutional
sounded
rights.
like-
And I don't, just because he wanted to plead guilty and get this over with, could actually mean the opposite. He didn't understand he was giving up these important rights.
Counsel, a minute ago, I thought you were saying that even the court's question, do you understand you're giving up your right to a trial? And he answers, yes, Your Honor, is not good enough. You're saying that question is not good enough?
I'm
I thought
saying
your
that-
argument was about the other two rights.
My argument is about the other two rights.
Okay, so this right, you think that question is enough?
I don't think it is enough. I
What
don't
else
know
does he
that.
have to do? Are you saying he has to explain what a right to a trial is
I
in
think by
detail?
explaining the other two Boykin rights, it gives meaning to the word trial. Just saying trial alone.
When have we ever decided that only saying you are giving up a right to a trial is not sufficient? Those words, as opposed to some other more detailed explanation of what a trial is.
This court hasn't said that.
Right, that's what I'm
Yeah,
asking
yeah.
you. So what case are you relying on?
I'm relying on
that?
Hansen v. Phillips case and the third department cases, Vensis and Monis, that looked at pleas and said, although the court said trial, they didn't say, there wasn't enough information on the record to affirmatively show
Okay,
that the
Counsel.
client pled guilty knowingly.
Thanks, counsel. Thank you both. Appreciate it.